huge welcome to the Next Your Employment webinar in the series, providing you with essential employment law and HR updates. For those of you that are new to our webinars, we are, of course, Jones Chase Employment Lawyers. We act for a number of companies, from PLCs all the way through to startups, and for some fantastic individuals as well. And we have a very high success rate of looking after those that we represent, which is north of 95%. And we're delighted to have you with us today. I'd just like to quickly introduce the team who's speaking to you. So first of all, we've got one of our senior associates, Harriet.
Hi, everyone.
And one of the firm's associates, Zainab.
Hi, everyone.
And our newest member of staff, one of the firm's paralegals, Jessica.
Hi, everyone.
Okay, so first of all, in terms of format for the webinar, if you want to ask us questions, please do use the Q&A box and hit the anonymous button if you want to ask questions anonymously. If you don't mind your name being displayed, you can use the chat box, which we'll be keeping an eye on as well. And which I think is a really good thing to keep the flow of the webinar going. If you use the drop-down menu and select all panelists and attendees when asking questions or submitting comments, then everybody can see what you're saying, and it's really good to keep the flow of the chat going. If you want to speak live, please do write this in the Q&A or chat box, and either myself or one of the team will unmute you so you can speak on the webinar. I should add that we are recording the webinar to allow us to distribute this to those that couldn't make it at 4 p.m. today. So please do bear this in mind if you're asking questions. And again, you can hit the anonymous button if you want to ask questions on an anonymous basis. I should emphasize that the points that we're covering today are not formal legal advice. So much depends on the facts of the case, and sometimes the approach that you take in one case is not the same approach that you take in another. So please do bear that in mind, and then definitely don't rely upon this webinar for legal advice as well. If you have any questions, definitely drop us a line. We'd be delighted to help you. As a quick reminder, employment law is always changing very quickly, and the information that we're covering today is accurate as of 4 o'clock on the 24th of November 2022. And we do appreciate that everyone's time is precious, so we will be finishing at 5 o'clock on the dot today, if not before. And lastly, we do like helping people. So if there's anybody out there you think would benefit from these webinars, or who you think would work well with us, definitely connect us, and we'd be delighted to be introduced to them. And we always like receiving referrals. Okay, so moving on quickly with the content of the webinar. Today, we're looking at the key employment law cost-saving strategies to help businesses during a recession. And as I mentioned in the webinar invite, the UK is currently facing a period of significant financial disruption, and we're already seeing the direct effect of this. But suffering a downturn in turnover does not automatically mean that businesses need to look to make redundancies, which is often the first thing that people do when their business is in threat and there's a little bit of panic going on. So as we'll see today, there's plenty of things that can be done within the scope of employment law to insulate businesses from the effects of a recession, to save costs, and also to help keep good teams together, which is the focus of the webinar. Redundancies can also be very expensive for employers, particularly when things go wrong and claims for example, unfair dismissal or for a protective award under the collective consultation rules are brought. And by way of example, if you have a group of, say, 25 people who bring in claims, depending on their salaries, the cost of dealing with the same could easily exceed 1 million, particularly when factoring legal costs as well. There's also the negative impact that running a redundancy program can have on staff morale, and employers are likely to lose some good people with significant company-specific experience that's been gained over many years. And it could be hard, very time-consuming and expensive to replace such people in the future when things pick up again. And all of this could have a big knock-on effect on the business's customers, and the company could end up losing turnover because of the downsizing, because the service isn't being delivered to the same high standards that it used to be. So whilst we fully appreciate that sometimes redundancies cannot be avoided, the purpose of today's webinar is to highlight that there are a number of other creative options out there that should be considered by businesses, as opposed to reaching straight for the redundancy option. We also appreciate that a number of the ideas that we're going to run through will absolutely not be popular with the employees. But in a difficult economic climate, staff may agree to various options which they wouldn't ordinarily do, with the hope that they can keep their jobs. So it's definitely worth thinking about these things. And just lastly, by way of background, there's a really good example from a company in the USA that in 2008 lost 30% of its turnover due to the recession. And this company needed to save a number of millions of dollars of cost, and the board met to consider what to do and also to discuss layoffs or redundancies. And famously, the CEO of the company, somebody called Bob Chapman, refused to let anybody from the company go, and they devised a furlough program where each member of staff had to take 4 weeks of unpaid leave within the calendar year. The key thing here really is how it was announced to everyone, And when he did this, Bob said famously that it is better that we should all suffer a little than any of us should have to suffer a lot. And this had a fantastic effect on the company. People felt secure and morale went up. And in addition, a number of unexpected things happened within the business. For example, those staff members that had more money and could afford more time on unpaid leave or furlough, they swapped their weeks with those that couldn't afford it as much, and with the effect that everybody got through the crisis together. So with that great example in mind, we've got together as a team and have come up with as many creative alternative options to redundancy as possible for you. And I'm going to screen share our list at the end of the webinar, so do hang on for that. And it'll also be available on our website as well. And of course, if anybody would like me to email a copy of our list to them, just drop me a line at dean.jones@jonesgs.com. I'd be happy to send that through to you. And lastly, by way of introduction, we always like our webinars to be interactive. So please do post your cost saving ideas in the chat box or otherwise in the Q&A box. And well, when doing so, do use the drop down option so it's set to all panelists and attendees so everybody can see what you're saying. And let's see how many of our ideas you've already come up with. And importantly, if there's any ideas of yours that we haven't picked up on, it would be great to see them and great for us all to share this information. Okay, and just before we go into the rest of the team section, who are going to discuss all of these different cost-saving measures, a lot of these actually involve changing terms and conditions of employment. So I'm just going to very, very quickly run through a 5-step sort of program, just a very quick summary, but in terms of how to change terms and conditions of employment effectively. Okay. Of course, the risk of getting this wrong can be pretty substantial, and messing up on a contract variation exercise, as it's also called, and that can include claims for or involve claims for unfair dismissal, for protective awards, breach of contract, and if relevant, claims for unlawful deduction from wages being brought. So here's a very short guide on how to do this effectively. And of course, as a firm, we have all of the documentation and guidance that you need to do this. So if you are planning on varying anyone's or your staff's contract and you do need a hand, definitely drop us a line. We'd love to help you. Okay, so 5 steps. Step 1, and the very first thing to do is to get your business case right. And this is going to be essential if you ultimately have to, which I'll come on to, dismiss and offer to re-engage a load of your staff members. The business case is really, really essential to justify the lawfulness of the dismissal, if you get that far, and also what you're doing in general. And furthermore, having a good business case and making sure that's effectively communicated to the staff will mean that your staff members will genuinely understand what is going on, and hopefully it will be more likely that they will agree to the changes in the first place. Okay, so step 1 is make sure that your business case is in good order and well communicated. Step 2 is to consider the terms of the contract itself, and it may be the case, depending on how the contract is drafted, that you're not actually making a variation at all, and the wording of the contract may allow you to do what it is you're planning on doing. So, for example, a place of work clause may say, it's maybe a bad example, but it could say you're required to work at anywhere that the company decides, for example, and meaning that if you want to make sure all your staff work from home for a while, that may not be a technical breach of contract, okay? And there may also be a variation clause in the contract allowing for changes to the contract to be made. But either way, it's never safe to rely on the contract wording entirely, and the company should still always act reasonably and provide staff with plenty of notice and the rationale for the proposed changes. Otherwise, there could be a risk of constructive dismissal or breach of contract claims being brought. And in this case, for example, there's the leading case is one about a mobility clause where the company could move a member of staff to work elsewhere, but did so on very short notice and unreasonably. And in that case, the employee argued that the implied term of trust and confidence was breached and brought a constructive dismissal claim. Okay, so step 2, just double check the wording of the contract itself. Make sure that whether it does or does not need actual amendment or changing. Step 3, if the wording of the contract does need changing and it doesn't allow for the change to be made by the company, then you're going to need to get the consent of each staff member to make the change, also known as express consent. And in this regard, I'm sure you'll all be aware, we do recommend consulting with the staff members. This can be done as a large group, but also we do recommend individual consultation as well. And furthermore, it's a really good idea to allow the staff time to think about the proposals and to allow these changes to kind of bed in their thought processes. And for example, 28 days could be a good period to run a contract variation exercise over. And 28 days is a decent window to allow the staff to voice their concerns before any changes are actually made by the company. And then ideally at the end of the consultation period, however long it is, the employer can then issue the new contracts to the staff or side letters to record their consent to the changes. Hopefully everybody signed up, but in almost all of the contract variation exercises that we've run, there's always some difficult people who just, usually about 5%, just want to push back and won't accept any changes. So in which case we move on to step 4 to step 5, which is to look at potentially unilaterally imposing the changes. Now, obviously, this is a much more dangerous thing to do, and effectively where you will tell the staff members, okay, from whichever date it is, X date, these changes are taking effect, and basically that's it. Now, if the staff members continue working for the company after that date, the company may argue that they've deemed to have accepted the changes by their conduct. This is known as implied consent. But the risk here, of course, is for people with qualifying service, that claims for constructive dismissal and breach of contract may be brought, because people could be pretty unhappy with what's happening. And also this implied consent route is not watertight, and that's particularly the case where you're dealing with a change that has latent effect. For example, if you're planning to reduce the company's enhanced sick pay scheme, the impact of which may only kick in once the employee becomes well at some point in the future. And then at that time, the employee can argue that he or she never agreed to the change in the first place. So unilaterally imposing changes on people, never a good idea, but may be essential. But we will strongly recommend legal advice is taken before we do that. Or step 5, which is another option instead of step 4, which is to dismiss and dismiss and offer to re-engage the staff on new contracts. And this has picked up some pretty bad press of late, and there's potentially a new statutory code of practice coming out about it. It's also known as fire and rehire. And this involves the employer, usually say the 5% of people who haven't accepted the changes or whoever's left, to terminate their employment on notice and offer to re-engage them on the new contract. Of course, this can give rise to unfair dismissal claims, and it should only ever be considered as a last resort. It can also be very damaging for morale. But depending on the strength of the business case and what the employer is proposing, these dismissals may be a potentially fair dismissal for unfair dismissal purposes for some other substantial reason. But either way, it's absolutely essential that a fair process is followed, and that involves a lot of consultation. Again, if you need any help with this, definitely drop us a line. I should add that if you're going down the dismissal and re-engagement route as a last resort, just bear in mind that if there's 20 or more people who may be losing their job, or even if temporarily by way of this route, then the collective consultation rules are triggered. So that's the same rules that apply to collective redundancies. So you do need to bear that in mind. Again, we can help with this if needed, and a failure to collectively consult, of course, can give rise to protective awards being made for up to 90 days gross pay per person. So it can be super expensive. Okay, so that's a very quick run through on how to effectively vary somebody's contract of employment. If you need to get some more advice, drop us a line, or otherwise this webinar will be on our channel on YouTube if you want to run through that again. So now I'm going to stop talking finally, and I'm going to hand over to Jess, who's going to discuss a number of the ideas that we came up with to help save costs for companies. So over to you, Jess.
Thank you very much, Dean. Yes, I'm going to run through a couple of ideas. I've got quite a few to get through. We've had a real brainstorm this week. But the first sort of area that I'm going to talk about is recruitment. And that's going to include sort of recruitment freezes, offer withdrawals, and start date deferrals. So a freeze on recruitment is an obvious way to reduce costs, especially in industries with a naturally high turnover, such as leisure and hospitality. A recruitment freeze is a particularly attractive option, as it will not usually have any employment law implications. That being said, there may be situations whereby an employer wishes to make the commercial decision to recruit an exceptional candidate for a critical role during a recruitment freeze. In these circumstances, legal issues may arise, particularly if there are individual or collective redundancies happening at the same time. To minimise this liability, the employer must ensure that the decision to dismiss existing staff for redundancy, then hire a new employee, is not tainted by discrimination. The employer may either have to offer employees at risk of redundancy the opportunity to retrain or reskill before making a job offer to an external candidate, or be able to justify the decision to make some employees redundant whilst recruiting another. The employer will probably have to consult on the issue or of a likely new recruit in any consultation process with employees or employee representatives. Failure to sort of consider any of these things may lead to claims for unfair dismissal and/or a protective award. So withdrawing employment offers before new employees join is also a very attractive way to reduce payroll costs without disrupting good teams that work well together. Generally speaking, an employer may withdraw an offer of employment at any point before it is accepted without having to give notice or make payment in lieu of notice. However, once an offer has been accepted and any preconditions attached to it met, such as receipt of a satisfactory reference or confirmation of professional qualifications, an employment contract is in place, even if the employee has not started work. The employer is unable at this stage to withdraw the employment offer and instead has to terminate the contract, either by giving the requisite notice or payment in lieu of notice. There are two main things to watch out for when considering withdrawing employment offers. The first circumstance is where an employer has already committed to a certain start date, which will often be stipulated in the employment contract. A prospective employee may be entitled to claim some notice pay if a job offer is withdrawn shortly before they're due to start work, if they are given less notice than the notice agreed in the new contract. Failure to pay this notice may result in a claim for a breach of contract. Second point to consider is that the rules on collective consultation and HR1 forms also apply to new employees who have signed a contract but not started work yet. It's important to bear in mind that withdrawn job offers may cause an employer to reach the collective consultation threshold of 20 or more dismissals within 30 days, either because 20 or more offers have been withdrawn within a short space of time, or more likely when these are added together with the redundancy dismissals within a 30-day period, and then it reaches the 20 maximum limit. Recruitment deferrals may be another option as an alternative to both an altogether freeze on recruitment and to withdrawing job offers. If a new joiner has already accepted an offer of employment, then there is a contract in place and a change to the start date will require their agreement. Dean has sort of covered changes to terms and conditions in his section. Deferring start dates works particularly well for graduate hires and apprentices who might be studying or might be able to pick up temporary work in the interim period. It's also a good option for where employers don't want to lose an exceptional candidate. I was actually chatting to Shona, one of the partners, about this earlier today, and she made the great suggestion of making a payment in sort of as an incentive for pushing back a start date. So, you know, you start in 6 months, but here's £1,000, enjoy yourself. Other commercial factors should be considered when looking to freeze or defer recruitment, such as whether it will be putting existing staff under too much pressure. The next thing I'm going to discuss is overtime. And another often straightforward way to reduce payroll spending is to reduce or ban overtime. When there is no contractual entitlement to overtime work, it's quite easy for employers to stop offering it. However, where there is a contractual right to overtime, for example, under a collective agreement, the employer must obtain the employee's consent again to stop offering overtime. When imposing an overtime ban, the employer must also consider the effect that this will have on different parts of the workforce, for example, on different age groups. Employers should ensure that any overtime ban is not discriminatory. Not only can employers reduce the rate of overtime hours available to be worked, but they can also seek to reduce the overtime rate of pay. This is a particularly good cost-saving measure where overtime is paid at a significant premium to regular working hours, rates such as double pay and time and a half. However, quite naturally, any reduction in remuneration is perhaps the most controversial and potentially problematic practice employers may adopt. Employers who need to reduce remuneration are advised to inform the workforce in advance, setting out in clear language the cost and benefit elements of such an exercise. When possible, management should also lead from the top by sharing in any cuts. Ideally, the measures should be limited in time with perhaps a promise for long-term improvements once market conditions change. Any changes to contractual remuneration should be done with the employee's consent again. It might also be necessary to comply with any information and consultation obligations if shift patterns are affected because of the overtime ban. So the next sort of section I'm going to talk about is reducing use of contract workers. Reducing the number of casual workers, agency staff and self-employed consultants may be a relatively low-risk way to reduce employment costs without making permanent staff redundant. However, before taking a decision to terminate, any engagement, the employment status of such individuals should be carefully assessed in case they legally qualify as employees with statutory rights such as statutory redundancy pay and unfair dismissal. This assessment will be incredibly fact-dependent and legal advice should be sought at the earliest opportunity. Once HR have completed an audit of the employment status of contract workers, consideration should be given to any liabilities that may arise as a result of a decision to terminate or change a contract. Following on from that, the next thing I'm going to talk about is redeployment and retraining. A good way of retaining key skills and avoiding redundancies is to redeploy affected staff elsewhere within the organisation wherever possible. Once again, this will need to be done with the employee's consent in the absence of an express right to redeploy in the contract of employment. Before putting in place redeployment or retraining arrangements, an employer is advised to consider the short-term and long-term implications of the arrangement on the business in relation to the benefits they're expected to produce, whether the arrangements are intended or expected to be temporary or permanent, the effect of the arrangements on the employee's long-term employment, training and promotion prospects, and the need to make redeployment or retraining offers on a non-discriminatory ground. Final thing that I'm going to talk about is secondments. Another headcount reduction option is to second an employee, either internally within a group or externally to a client that needs additional resources or expertise, for example, if they've had to make redundancies. External secondments are often valuable commercial arrangements which allow the seconder to reduce headcount and enhance employees' expertise. However, they are only a temporary solution, and at the end of the secondment, the employer might be back to square one, having to make a decision about potential redundancies again. In addition, in the event of an upsurge in work or demands, the seconded employee might not be available for many months if they've been seconded to a client. That is the end of my section. I believe I'm handing over to Harriet. Thank you.
That's my first time in 2022 I've done that, I think. Okay, sorry, I was on mute. Thanks very much, Jess. And yeah, I'm just going to say we can try to make this webinar as interactive as possible. So the team, we've actually come up with 18 ideas to save costs using employment law. So for the participants here today, definitely dive in on the Q&A and just put your ideas forward, even on an anonymous basis if you want. And just before you move on to Harriet's section, so we've had a quick question, I think, based on something I was speaking about from an anonymous attendee who's asked, if the new contract terms are disadvantageous, do you need to make a standalone payment to ensure there's consideration for the variation? The answer to that is generally no, because there's established case law to say that continued employment is actually consideration for the change itself. However, without getting too technical, when you're dealing with things where the issue's deferred, such as post-termination restriction changes, or otherwise, as I mentioned earlier, maybe a change to the company's sick pay regime, then it can be argued that there was the continued employment wasn't due consideration. There's case law about this as well, in which case a small financial payment would be advisable or some form of consideration when you're making the contract change itself. But generally, no, you don't need to offer money. It just depends on the changes. But if you're in doubt, just definitely drop us a line and we can advise you on that as well. And okay, so another quick question here from another anonymous attendee. If an employee withdraws an offer, are they required to make contractual notice in lieu? There's a lot of case law about this as well, and we've looked at it recently. Generally speaking, the notice period is payable, although just double check the contract to see whether the employee would be in their probationary period. A lot of it depends on the whole timing as well. So it is a bit tricky, but it's safe to assume that yes, a notice payment would be payable. Okay, unless anybody else has anything to add to that. No, I know there's some pretty horrible case law around that last point. Okay, I'm just, I think as Jess said, it's Harriet next, I believe, isn't it? Or Zainab, sorry.
Yeah, I think it's me. Fine, I'm happy to happy to speak next. Thank you. So I'm going to have a look now at some points where we're actually looking at a sort of a temporary stoppage of work. Jess has sort of considered some interesting points in terms of reducing headcount, that kind of thing. So, but I'm going to look at what can you do to actually pause that work if necessary, or just to stop people actually being at work or having to pay them. So the key things I want to look at are layoff and short-time working, a quick word on sabbaticals and unpaid leave. So obviously, if you're looking for alternatives for declaring redundancies, things like laying staff off on a temporary basis or reducing their working week might be things that you might want to consider. They're a bit more draconian than the things that Jess was speaking about, potentially because it may affect more of your workforce, but it's a temporary solution to the problem if you've got less or no work for a limited period. Whereas obviously dismissal, more draconian because it's sort of irreversible and you're keeping people together, which is what we're looking to try and achieve. But it can help with a sort of unexpected downturn in business, typically, or sort of some unforeseen circumstances, if production at a company's premises were interrupted, to save money for a limited period. And that's why typically these things have been used in sectors such as manufacturing, where these kind of things are more likely to happen for certain types of worker, those working on the factory floor or piece workers. But actually, in the recent economic downturns, we have seen layoff and short-time working used more widely, and sometimes in the professional services sector and for salaried employees. So it is something that's become a bit more widely used, I think, particularly since the pandemic. It's been something that have been on people's radars in terms of, gosh, if I need to suddenly not have people working for a limited period, how do I do that? And layoff is basically when an employer provides employees with no work and therefore no pay for a week or more, but you keep them as employees. So you're not dismissing them, you're just not providing them with work for a temporary period. And short-time working is when the employee only works part of a week and receives this sort of proportionately reduced pay whilst being an employee. So it would depend on whether you need people to sort of stop work entirely or just do less work. So I'd look at layoffs first. And as I said, they've become more common during periods of economic uncertainty for a short-term period and a sort of a temporary slowdown in work. So if you think things are going to pick back up again within a relatively quick time, then it may be something that's appropriate. And as I said, the employees are still employed, and that's why it's popular, because it's an immediate saving of labour costs, but you've got that flexibility to bring people back when things start to pick up. But from a legal perspective, what's really important is that employers don't have the automatic right to lay staff off just because business may be down. You've got to have a contractual right to do this. And the contract has got to make clear that employees are not going to receive their normal salary during this layoff period. And that means you need an express clause written into the agreement. And we've been doing this more and more when we're providing contracts for people, is including layoff and short-term working clauses in the contract, just so it's there in case it's something that you want to use. Some employers operate within industries where, through custom and practice, laying off employees or putting them on short-term working it has created an implied right to do so. But we would always advise that it's best to have an express clause. And if you were to lay people off without having this clause, then what you need to be aware of is a repudiatory breach of contract. So you'd be looking at some potential constructive dismissals, and if people aren't being paid, unlawful deduction from wages. So it's definitely not something that you want to jump into if you don't have the right in your contract. If you don't have the right in your contract, which many companies won't have, then you're going to have to consult. So going back to what Dean talked about earlier in terms of changes to contracts, you're going to need the employee's agreement. So all the sort of consultation and the risks and things that Dean talked about earlier would apply. But as Dean also mentioned, I think under normal circumstances, employees are not going to want to agree to this. But if you've got really good communication and the employees can see that the alternatives are either closing the business or job losses, they may be more willing to reach an agreement where they temporarily stop work for a period, if they can see that that's then going to be sort of the greater good, and they'll be back to work in within a period. Complications can arise if you only need to lay off some staff because you need to keep things going, but you can't afford to have all of your staff working just for a short period. So you would need to think about how you're going to select those employees that you are going to lay off. There's no criteria for laying off employees in statute or case law. It's not sort of the same test as a redundancy exercise that we'll be familiar with. But we basically advise that you approach it in a similar way, that you have reasonable selection criteria and go through it as if you would in a redundancy exercise in terms of what are the criteria that we need for those staff who are going to be carrying on working in the business. And obviously, make them objective. You want to avoid disputes and grievances, not discriminatory, not breaching trust and confidence, and to try and agree the criteria when consulting, as you would in a redundancy situation. Just to mention, I'm not going to go through the legislation that governs sort of temporary layoffs and short-time working, because it's quite complex and it actually isn't used that often in practice. But just a couple of key things to be aware of is that the legislation provides a right for employees who've been laid off or kept on short-time working for 4 or more consecutive weeks, or 6 weeks in any 13-week period, to claim a redundancy payment in certain circumstances. So the key point here is, don't keep them laid off for longer than necessary, and just be aware of this sort of time limit, because you could then incur redundancy costs if they're kept off for too long. And there is a very low statutory wage protection scheme for employees who are laid off without pay. This is referred to as guaranteed payment. And it's really, really low. And the maximum is currently £31 a day. It goes up each year like the other employment statutory payments. But the entitlement is limited to 5 days in any 3-month period. So it's very low. So you really want to make sure when you're seeking agreement with employees to lay off, that they are understood what the financial implications are, and everything's agreed and recorded in writing. So that's layoff. So short-time working, so less draconian, you're reducing an employee's hours and therefore a corresponding reduction in pay. And as I say, it can be effective at avoiding redundancies, but doesn't stop everybody working. They guaranteed some work and some pay, and therefore, as before, people are more likely to accept this as an alternative to possible redundancy if you're having to consult with employees. And again, you need to have the contractual right to do this, or seek express agreement and consult, and be aware of the guaranteed payments that will apply in certain circumstances. And again, I won't go through that because it gets a bit technical, but just be aware that there may be something that needs to be paid when they are not working, and the potential redundancy payment that can be incurred if they have to work for a certain period of time. If you do have to give employees notice of termination during a period of short time working, just be aware that they might be entitled to be paid their normal salary based on their normal, not reduced hours of work during the notice period. So again, it's a sort of technical point to just bear in mind if you are looking at that and you do need to sort of terminate people's employment. And I think you want to make clear that the short-time working arrangements are intended to be temporary, and that the employees should be available to return to a normal pattern of work. So you want to make sure that you put in writing that when you want them to come back to work, they're going to do that or go back to their normal pattern. You don't want to agree a permanent change to their working hours unless you definitely want to do that. Zainab's going to be talking about sort of flexible working and those kind of changes, part-time working. But obviously a permanent reduction in hours has got different implications. And just lastly on this topic, ACAS has got a guide to layoffs and short-time working. It sets out the basics in the area. It's not particularly detailed, but it's got a sort of basic rundown of the law. And I'm just going to quickly look at a couple of other suggestions which also involve a temporary cessation of work. Firstly, looking at sabbaticals. Now these are quite interesting. We do quite often get asked about sabbaticals or career breaks, also refer to them, but they're not a legal concept. I mean, it simply just means time away from work. We find that many sort of public sector organisations have sort of official sabbatical policies in place, and some allow employees to take sabbatical every few years. They may have a contractual right to do that. They are less common in the private sector, but they're obviously something that some employers may have on a regular basis, or they're something that so you've got kind of recessionary times. It's something that you can adopt and have this sort of unpaid period away from work, which can help reduce costs and therefore then retain the employees. And again, if it's positioned to employees as a way of avoiding or limiting the need for redundancies, people may find, and we have found in the past, that people are happy to take up this offer for the greater good of the company if it means that ultimately jobs are going to be saved. And some staff who can afford to take the time off work, like Dean said in his example right at the beginning, some people, they may be in a financial position where they can and actually want to take the time off work. So they may put their hand up for a sabbatical and be able to use that time to change their lifestyle, do something, write a book, something they've always wanted to do, and they've got the promise of a job on return if that's what's agreed with them. And generally with a sabbatical, you're going to preserve continuity of employment. So again, you're not losing your team, you're keeping people on the books, but this applies for both statutory and contractual purposes. So one potential downside for the employee is, whilst you can agree with the employee that they won't be paid their salary, they would still accrue statutory holiday. So that's just something to bear in mind. And it's not normally something that you can unilaterally enforce. Otherwise, this is effectively layoff without pay, with sort of by the back door. And you may not want to offer it to all employees. Often you have some kind of service requirement for eligibility, so people have been there for a certain amount of time. But obviously, you may want to be clear that this is a discretionary thing and reserve right to refuse people's request if someone is essential to the business and you don't want them to go off. So you have to think about how you position it. But I think however you do it, we would suggest that you have a written sabbatical agreement. So you're really clear on what the terms are. So how long is it going to last? Can it be extended or shortened? What they're going to be paid? What happens to benefits, pension, holiday, confirm continuity of employment. Importantly, do they have a right to return to their old job at the end of it? And if so, what's the salary going to be? Is there anything they're not allowed to do during the sabbatical? So you just have to think through, okay, well, if that person then wants to come back to work after 6 months, what do we do if ultimately we then don't have a job? You're obviously looking at potential redundancy situations. But it can be something that works quite well in some businesses. And the last point I just wanted to talk about was unpaid leave. I think that's obviously was in Dean's example that worked really, really well for that particular company. But again, it can be like sabbaticals. It can be something that normally shorter than a sabbatical. Sabbatical normally be for a number of months. Unpaid leave could just be for a few weeks here and there. But the same factors are relevant. Obviously, you're going to need employees' consent unless the employment contract or any sort of collective agreement that might be in place allows an employer to place employees on unpaid leave, but that's not common in my experience. Some employers might have an unpaid leave policy, which may have restrictions or preconditions, but you might then want to say, right, we're going to take all those conditions away, because you want to encourage people to take up that suggestion of taking unpaid leave. So that was the end of what I wanted to talk about. So I can hand over to Zainab, I think.
That's great. I was just going to jump in, sorry, and to say the things that you mentioned, if the employer gets those right, tens and tens of thousands of pounds can be saved with layoff, short-term working and sabbaticals, for example. Obviously there's risks, but yeah, depending on the circumstances, if it's done correctly, it can be hugely beneficial, and keep good teams together and maybe save the company as well. And sorry about that. And I'm sorry, just one other thing that's really bugging me, sorry. The question I was asked earlier, or we were asked, if an employee withdraws an offer, are they required to pay contractual notice and leave? I forgot to say that it depends on if the person's accepted the offer or not, and if a contract's in place. If the offer's been made, I think it can be revoked, generally speaking. But if the person's accepted to sign the contract, then we're looking at a payment of some description will need to be made. Okay, sorry. Yes, over to you, Zainab.
Thank you, Dean. So I'm going to be talking firstly about flexible working, part-time working, home working, all of that stuff, which we spent a lot of time going over during the pandemic with all of you. But introducing part-time working or job sharing is a really good way of reducing costs. It also could be good incentive for employees if they're looking to improve work-life balance. So with job sharing, the good thing about it is that you retain the level of responsibility or strategic weight behind a full-time position. Employees enjoy the flexibility of part-time hours. There's an exchange of skills and knowledge between the job sharers, but obviously there could be problems in respect of consistency, especially in the beginning when they're first getting to grips with the job sharing role. And that could be problematic for you if you have, if you're a client-facing service. So that's something to bear in mind if you are considering job sharing. So with flexible working, part-time working, home working, all of these, you want to start by asking for volunteers and ideally obtaining consent to vary people's hours. But as Dean has already mentioned, these things can be implemented unilaterally if needed, and Dean's covered the pitfalls there and the risks that are potentially there if you do opt for that route. Another cost-saving option could be to encourage employees to work flexibly or remotely. So this could be full-time home working or hybrid working, where some of the employees attend the office for part of the week and the other half of the employees attend the office for the other part of the week. And the benefit there for you is that you could get a smaller office. Now, obviously, that's dependent on how quickly you can get up your lease and whether you can find a smaller office and all the costs that are incurred in respect of that. But that is something that that's the benefit of hybrid working or home working. If you do, agreements that allow employees to work from home could also include asking them to agree to a lower salary in recognition of the fact that they are able to live in a cheaper area or they're avoiding commuting in. Where employees' consent is not forthcoming, you can potentially seek to rely on a flexibility clause in your employment contract or consider terminating and re-engaging on new terms, again, as Dean covered earlier on. So employees with at least 26 weeks continuous service are entitled to request flexible working arrangements. You may well want to accept applications from staff with less service through this period if it's going to be beneficial to you. And with all of these kind of changes to how employees work, you want to agree, the precise changes to work conditions. So what are the new hours? What are the days? Where is the location? How the agreement affects employees' pay, benefits, and pension arrangements. Have that very clear and have that in writing. How long the arrangement will last for. So, for example, it could last indefinitely, or it could be for a pre-agreed period, and then there could be a review. There could be arrangements, subject to a probationary period. This could be the case if you receive a request from someone that you think actually their job's not really going to work that way around, but you've offered this flexible working option to everyone. So you could have a trial period in those circumstances, and whether these arrangements will affect future training or any promotion prospects or anything like that. Obviously, you want to limit the negative commercial impact such arrangements might have on staff motivation and morale. And we've covered this, everyone's kind of mentioned this, that things should kind of be dealt with from the top up. So people making changes in leadership as well as lower down within the company. Like I said, with these arrangements, you can also apply them for a limited period with the option to extend. And also you should retain the right to terminate the arrangements or cater for any increased demand once market conditions have improved. With these, you want to be careful not to discriminate against part-time employees. They shouldn't be treated any less favorably than full-time workers. There are also practical issues to consider, which we've been through in a number of different webinars, including, especially with working from home, things like monitoring, recording core hours, access to IT systems, health and safety. We actually had a question in from Laura prior to the webinar. I'm not sure if Laura's on the webinar, but I'm going to answer her question anyway. So Laura asked a really great question. She's asked, I'll just read it out to you. So we are looking at savings on office costs versus employees being official home workers. This is something that many organisations have probably looked at due to new ways of working after COVID. I understand there is no obligation to pay home expenses. That's correct. But how would this work for mileage expenses? And is there an obligation to pay all expenses from the home? And she's also asked, is there anything else that is an HR pitfall that is forgotten in these circumstances? So Laura, you're right. You don't have to pay expenses, but you can agree to if you want to. ACAS recommends having discussions with employees about who will cover the extra costs that employees might have from working from home. And the contract should specify which expenses employees can claim and how, or this should be included within home working or hybrid working policies. There was a 2017 Employment Tribunal decision called Newman and Arrow Promotional Limited, where the tribunal actually implied an expenses clause into Mr. Newman's contract because there was no contractual term either way as to whether expenses should be paid or not. and he'd been working from home for 2 years. The company went into liquidation. But so it just be clear on whether you are offering it, and if you are, what it is. Okay. In respect to the mileage point, I think what Laura is saying is that if your home becomes your place of work, then arguably everywhere you go is potentially going to and from work. So it would be absurd for an employee to claim every journey from their home to anywhere else they would go as an expense. And as a starting point, you don't have to pay mileage for an employee to come into the office from their home. But if you decide to, again, you just need to be really clear in respect of what can be expensed, set out the terms, the boundaries of what you're offering really clearly. And just be careful on tax on this. We're not tax lawyers, so we can't advise specifically on that point. And then just in respect of pitfalls with regarding expenses. So 2 main things to be aware of. So as an employer providing home working expenses for your employees, you have certain tax, national insurance and reporting obligations. There's actually really helpful guidance on it on the government website. And then the second thing, and I've said this about 3 times in answering that question, but you need to clearly define what will be paid and what won't be paid. And it needs to be kind of, you know, in the contract or within policy, so that it's very clear what you are offering, and there's no ambiguity as to that. Okay, I'm going to go on to pay and benefits. So employees' working hours are usually a condition of employment, which are the arrangements that are put into place at the very beginning of employment. In the past, I think employees may well have objected to any reduction in working hours and thereby reduction in pay. But the tide has changed, and obviously we're in very difficult circumstances now. And I think employees are more aware of the need to adopt, for example, 4-day working weeks. That's quite popular at the moment, to secure job stability for the team, for the workforce as a whole. Okay. So hours may be reduced as a temporary measure by way of a permanent change to terms and conditions of employment. If you are seeking to adopt shorter working hours, then we suggest that you explain to employees the financial impact of such cuts, both on them individually in terms of salary and benefits and the reduction to those, and on the organisation on the whole. So, for example, how many jobs would be saved if the measures are adopted. And again, management lead by examples, voluntarily taking pay cuts, waiving bonuses, things like that, which I'll get onto when I discuss discretionary benefits. So in respect of pay, normally if you pay less than what is required under the employment contract, you could face resignations, you could face a claim for breach of contract or unlawful deduction from wages. If employees make successful claims for unlawful deduction from wages, they could potentially also recover compensation for financial loss, which is attributable to the matter complained of. Failure to pay can also nullify any restrictive covenants that exist in employment contracts as well. So that means that if you are intending on paying employees less, the contract requires genuine consent of an employee, ideally, to put you in a situation where you can avoid those claims. There was a case against Asda, I think it was in 2009, I'm not sure actually, there was a case against Asda, Bateman and Asda stores, where the Employment Appeal Tribunal upheld a decision that Asda was entitled to rely on a general statement in their employee handbook, which reserved the right to vary contractual terms in order to introduce new pay terms without the need to obtain consent from employees. But this is a very fact-specific case, and in reality, Asda had undergone extensive consultation with employees. They did have this clause in their handbook, but they'd undertaken extensive consultation with employees. And in reality, the financial impact, they were just trying to harmonize pay across the country, and actually only financially affected someone to their detriment, one person. So it didn't affect the thousands of employees financially. So in reality, we think that, you know, if these kinds of changes, especially if the employees suffer as a result, having lower pay, lower benefits, they should be dealt with as properly as possible and should be consulted on, especially. Now, another option in respect of pay is to implement pay freezes. So most employment contracts will say that, you know, your salary will be reviewed regularly, usually annually. Some employment contracts give a right to annual increases in pay. You need to check if you have those, because that might be a risk if you're coming up to those dates where employees will be expecting increases because it's in their contract. To the extent that the contract only promises salary reviews, it is permissible for you to freeze pay once you've carried out the review. Now, commercially speaking, it's not likely to result in a breach of contract claim, but a salary freeze could be viewed by employees as a pay cut because they won't be getting an increase that they would ordinarily get. It's likely to reduce motivation and morale. So it should be well managed. Again, clear communication from the leadership and from the top, basically. Also, pay freezes in themselves are not going to may not be able to avoid redundancies alone. So you may want to adopt, this actually goes for all of the suggestions we're making, a few of the options together to kind of see what works for your business. Now, with benefits, so it's open to employers to cease providing discretionary non-contractual benefits, such as Christmas parties or refreshments at meetings or team days away. However, where benefits are contractual, either because they're actually in the employment contract or in collective agreement, or because they're implied into it, the withdrawal of a benefit would require an employee's consent. Okay. Employment contracts often describe bonuses and other benefits as being non-contractual or discretionary, implying that the employer is entitled to just withhold them or to reduce them. But such contractual provisions aren't immune from legal challenge. So you should be in a position to demonstrate that you've exercised contractual discretion. You've not exercised contractual discretion arbitrarily or irrationally. And, you know, alternatively, employees may be able to argue that they have a legitimate expectation of a bonus or other benefit as a result of custom and practice, and that's given rise to an implied contractual right. Whether you can withdraw or cut down bonus payments depends on whether the arrangements are discretionary or contractual, as I've said, or whether the bonus payment is designed to reward past or future performance, and whether it depends on individual or collective performance as well. As with all other contractual terms, if the bonus arrangements are contractual and the preconditions for making the payment have been met, then you will need consent to vary. If the arrangements are discretionary, again, you can't, your discretion needs to be exercised reasonably and non-capriciously. Absolutely, benefits if they are going to be cut, should be done from the top as well. It won't look great if everyone in the senior leadership team gets a Christmas bonus, but then there's no Christmas party for anyone in that's, you know, doing the work day to day, or the employees. So just bear that in mind too. And the last thing, very quickly, is just tightening up on policies. So you can amend non-contractual policies to meet any change in commercial needs you might have. However, with policies, you may have policies that are expressed to be non-contractual, so things like sick pay or enhanced redundancy, but and your expenses policy, but these could become contractual through regular application. And where a policy is contractual, then you need consent to vary it. It's become common for employers to tighten up expenses and travel policies. So this could include limiting the maximum approved spend, the approved class of travel, and introducing approval requirements prior to any expenses being incurred, as opposed to employees incurring the expenses and then just submitting their receipts to be repaid. And that's everything from me.
Okay, that's great. Thanks very much. And we've just got a few minutes left. So what I'm going to quickly do is we've had no further questions in that I can see. I'm just going to screen share all of our ideas so people can make notes. And once again, if needed, I can email these slides to everybody. Actually, we may put something out on LinkedIn about it as well, potentially. There's 18 of them from memory. Yeah, 18. So I'm just going to hold this up on screen for a little while. And for those people who are just listening to this by audio, I'll just read them out. So the ideas that we came up with are number one, freezing recruitment, Number 2, deferring new starters. Number 3, withdrawing job offers for new starters. Number 4, reducing or banning overtime. Number 5, reducing the use of contract, or external agency or self-employed workers. Number 6, redeploying your staff and retraining them. So rather than rehire other parts of the business, you can move potentially redundant staff into them. You never know, it may work. Secondments as well, again, can be very useful if there's another part of the organization or another company that can afford your staff. You can second people out for like 6 to 12 months, provided you get consent, of course. That could work really well. Number 8, as Harriet's covered, layoffs and short-time working. Number 9, sabbaticals. Number 10, using periods of unpaid leave. Number 11, flexible working in terms of reducing people's hours or asking people to go part-time. Number 12, flexible working in terms of job sharing as well. Zainab covered that earlier. Number 13, reducing or cutting completely discretionary benefits. And moving on to the last slide here, quite a dangerous one, well, in terms of the latter, but voluntary or enforced pay cuts could be done on a temporary basis, of course, as well. Very much needs to be wrapped up in a good contract variation exercise, that one. Number 15, tightening up on expenses and travel policies, as Zainab's covered. Sorry, with 2 15s. 16, pay freezes. 17, flexible working. In terms of getting people to work from home or hybrid working, you can save huge costs in terms of downsizing the office, or even getting rid of the office completely, as some companies have famously done following the lockdown. So number 18, reducing pension costs for the employer. Now, there's not enough time to go into this in the 2 minutes we have left. There's specific rules that you need to follow if you're consulting or making pension changes, bear that in mind. But you could agree a temporary reduction in employer pension contributions if you're paying more than the statutory minimum. And number 19, you can reduce the use of third-party providers in in-source work. And for example, what we mean by that is, let's just say, for example, you have another company that does all of your word processing or IT or something else, maybe outsource admin. Can that work be absorbed internally, and can you bring that work in-house to give to the staff that you currently have? And then you're not paying a third-party company to do that service for you, whatever it may be. So do think about that. Obviously, if you're doing it, just be very careful about the potential of a TP transfer as well, because you don't want to inherit staff that you otherwise weren't expecting to. So yeah, do take legal advice on that as well, if you're planning on bringing staff in, or in-sourcing work even, I should say. Okay, well, thanks very much. That's the end of the webinar, and everything we've covered today is accurate as of the 24th of November 2022. It's been a pleasure to have you with us, and we'll be back in, I think, the final webinar of the year in December, where we're probably going to look back at some of the key legal changes of 2022 and have a Christmas quiz as well. So that's all from us today. Thanks very much for attending, and we'll see you soon. Take care and bye-bye.
Thanks.
Bye.
Bye.